Hey everybody, Jeff Cooper here of Cooper Estate Planning and Elder Law. I want to talk to you today about a common mistake that we see when parents of minor children try to name beneficiaries. And so if you're in that position, try not to make this mistake. Alright, so here we go. There are several reasons why someone who's inheriting may not be capable of receiving an outright distribution. They could have a disability or incapacity or any manner of things. Maybe they've got a spouse that you're not too fond of if you're the person giving them money. But in this situation, it's a minor child, and so he was 16 at the time the will was written, and his dad was trying to figure out, how do I get money to him in the best way possible? And unfortunately, he chose the wrong path. All right, let's take a look at this will. I already got it pulled up here. As you can see, item number 5, to my son, redacted, son's name. And please forgive the grammatical errors here. I give colon, and then it starts a brand new sentence. Funds in my life insurance policy with AFN will be gifted to my only son, redacted name, of course, redacted name of his mom, that's the decedent's mom, the testator, the person who wrote the will, shall execute/oversee the funds in the aforementioned account. And he names a successor. My brother shall execute/oversee the funds in the account in the event my mom is not able to. Funds shall be placed in a trust until my son reaches the age of 21. Then it names his birthday. And so, unfortunately, what happened in the beneficiary designation form of this life insurance policy was that he said, hey, it goes to my mom. And the expectation was that decedent's mom was going to manage that on behalf of the one and only son, her one and only grandchild, actually. Regardless of how strong he might have thought that relationship was, in her view, it was more important to just keep the money to herself than to do the right thing. And so that's what we try to encourage clients to consider, is like, there are so many ways to actually do this in a more airtight kind of way than to just give the money to someone who is not the end user. And so one of the things I would stress is to, first off, never beneficiary designate money to someone who is not the end user. That's not a good idea. It just doesn't work out well. And even if the money actually gets to the person who's going to be the end user, it may cause some taxation issues for the person who receives it. There's a whole host of things going on there that you just don't want to bring into play. And then secondly, he did not consult a lawyer for this will. This is rocketlawyer.com or something, and that there's nothing inherently wrong with the documents that those services provide people. But the problem is the people signing them have no idea what they do. A lot of people ask me sometimes, hey, I'm going to go to LegalZoom or something, or I already did that, and do you think I have a valid will? And I'm, more often than not, my answer is probably, yeah, you have a valid will. What does it do for you? Which of your property items does it pass? And a lot of people don't know that. So, the counseling, the element of understanding what your plan does is a lot more important than, can I get my hands on a valid document for $100 or something, whatever they're going to charge you. So, getting off my soapbox for a second, sorry about that. But, a lot of people just think I'll name a trustworthy person to whom all of my stuff should go, and then that person can take care of all the other people in my plan, and it just normally does not happen that way. So I would encourage you to do it differently. Feel free to reach out to me if you have any questions about that. Again, Jeff Cooper of Cooper Estate Planning and Elder Law. Thanks a lot for your time.